If you have kids in college and you want to make sure that you'll have the legal authority to help them, then you must put in place these 3 vital estate planning documents right now. Hey guys, Elliott Feldman here, estate planning attorney at the Elliott Feldman Law Group, where we create estate plans that actually work when your loved ones need it most. If you ever have any questions about this topic or need to talk about your estate planning needs, you can schedule a time to talk with me over the phone for free by going to myestatemeeting.com. Entering your first year in college is a major step in a child's life. It also comes with serious responsibilities that you and your child probably aren't thinking much about right now. You see, once your child turns 18, they become a legal adult, and specific areas of their lives that were once under your control as their parent, like their health care and finances, will be solely your child's responsibility because now they're an adult. Why is this a problem? If your child gets into a severe car accident and requires hospitalization, you would no longer have the automatic authority to make decisions about his or her medical treatment or handle their financial matters. In fact, without legal documentation, you wouldn't even be able to access his or her medical records or bank accounts without a court order. If you want to make sure that you would have the ability to make decisions about your college kids' medical treatment or handle their financial matters in these types of emergency situations or otherwise, then you must have your child sign these 3 vital estate planning documents right now. Number 1, medical power of attorney. A medical power of attorney is a document that allows your child to grant you the immediate legal authority to make healthcare decisions on their behalf if they become incapacitated and are unable to make those decisions for themselves. For example, the medical power of attorney would allow you to make decisions about your child's medical treatment if he or she is knocked unconscious in a car accident or falls into a coma due to a debilitating illness. If you have no medical power of attorney in place, then you'd have to petition the court to become their legal guardian before you could make these medical decisions for them, which, as you can imagine, will be slow and expensive. And while a parent is typically the court's first choice, it is not guaranteed that you will be chosen by the judge to be your child's guardian by the end of it. And due to HIPAA privacy laws, once your adult child becomes 18, no one, not even a parent, is legally authorized to access an adult child's medical records without his or her prior written permission. But a carefully drafted medical power of attorney will include a signed HIPAA authorization so you can immediately access your adult child's medical records to make informed decisions about your child's treatment. Number 2, living will. While the medical power of attorney allows you to make healthcare decisions on your child's behalf while they're incapacitated, a living will is a document that your child states how long they would want to remain on life support until they want it removed to be allowed to die naturally. So that burden is not left on ultimately your shoulders to decide for them. By having your adult child make their decision on this matter now, your family would never have to go through the long and costly family conflict that arose when Terry Schiavo's family was stuck fighting over whether or not to remove Terry from life support. Number 3, financial power of attorney. If your adult child becomes incapacitated, you may also need the ability to access and manage their finances, and this requires your child to make you their financial power of attorney. This is the document that gives you the authority to manage their financial and legal matters, such as being able to deposit money in their bank accounts without you having to ask them for their account numbers, and paying for your child's bills out of their accounts, among other financial decisions that you might have to make. And without this document, you have to petition the court for such authority, which again will be slow and expensive. So in summary, if you'd want to make sure that you'd have the legal authority to help your children in college with their health care and finances, especially in emergency situations, then you need them to sign a medical power of attorney, living will, and a financial power of attorney document. If you'd like putting these documents in place, then please schedule an initial 15-minute call with me so we can discuss how we can do just that. You can schedule that 15-minute call with me for free by going to myestatemeeting.com. Hey, thanks for taking the time to watch this video. Don't forget to hit that subscribe button and the notifications bell next to it to be notified for new videos I post each week. And if you like it, then please hit the like button. And if you know someone that needs to hear this, please share it with them. If you have a question or comment, please leave it. And if you ever have any questions about this topic or need to talk about your estate planning needs, you can schedule a time to talk with me over the phone for free by going to myestatemeeting.com. That's myestatemeeting.com. Again, this is Elliott Feldman, estate planning attorney at the Elliott Feldman Law Group, where we create estate plans that actually work when your loved ones need it most. Take care.